So, when we talk about the incorporating documents for a company, we speak about the memorandum of association and the articles of association. These are two documents that have to be prepared by the promoters of the company. They have to submit the same before the registrar of companies. The registrar of companies will evaluate. For example, in the memorandum of association, one thing that is called as the name clause. So you have to choose the name of the company. And interestingly, the name of the company cannot be similar to the name of the company that exists already here. So it has to be unique, right? Because you will be known by that name. Similarly, the Articles of Association is another document which has to be prepared. For example, in the Articles of Association, how does the company manage its own affairs? Now, for example, the board of directors, right? The board of directors is supposed to be the representative of the company. Right? They will act on behalf of the company. They will make the company functional. Because the company cannot act on its own. It needs people to act on its own. So how does the board of directors function? Right? Who will have what powers? When would a special resolution be required? When will be an ordinary resolution be required? So all of these are written in the Articles of Association, and based on these two documents, a company comes into existence. Right? Now, these two documents are the guiding documents for the company to function. It defines the capacity of the legal person or the company as it is. Similarly, when you look at a university, it's the statute of that university that guides the formation as well as the functioning of the university. Right? It's kind of the regulation document for the university. And the university is guided by, okay, what is the capacity of the Vice Chancellor? What he can do and what he cannot do. Right? What is his capacity is defined over there. Secondly, maybe, the Vice Chancellor has to speak to the registrar, and the registrar has these kinds of functional capacities. So they have to act within those capacities, right? And that is when the company or the university would have acted within that kind of capacity. So the point is, friends, the concept of what we call as intra-virus and ultra-virus. Friends, intra-virus means within the authority or capacity. Ultra-virus means beyond the capacity or the authority. Ultra-virus, right? Something that was not permitted to you, but you have done it, and hence it is ultra-virus. It is beyond the scope. So legal capacity and incapacity will be judged by the incorporating documents, by the registration documents, and that is when actions will either be treated as intra-virus or ultra-virus. Okay? So this, friends, is very, very important vis-a-vis, say, what we call as corporate law or any other law. And in contracts, friends, please note, unless a company has the capacity to enter into a contract, anything that it does may be considered as ultra-virus in the company. To give you an example, I think the best one would be this case called Ashbury Railway Carriage Company versus Ritchie. Now, companies, friends, you notice, have what is known in the memorandum as an object clause. What should be the basic object of the company? What they should do and what they should not do. Now, object clause defines the business purpose, or what should be the business-centric approach of the company. So, a railway carriage company, fine. The object, if it is, say, to provide for the production and maintenance of railway carriages. Okay? If this is the object, if they decide to award a contract or get into a contract for something else, right, which is not defined in the object clause, please know that would amount to an ultra-virus action of the company. So every company defines its object clause. Say a software company defines its object clause as being in software services. Now, if they get into software production, that may be beyond the object clause. So the object clause has to be designed in such a manner that it gives some kind of flexibility to companies to, stretch a little bit here and there, because that is what business expansion is. Or else, it is important for companies to actually amend the object clause whenever they decide to award contracts or do any kind of transaction or activity beyond what is their code mentioned in the object clause. Right? So that's how I think the capacity of juristic persons becomes a critical factor in judging contractual capacity as well. Second, I think very importantly, you will notice, friends, insolvency. Solvency means you have capacity, insolvency means you lose capacity. Friends, insolvency is a position where a person has more debts than his assets, right? And he's unable to discharge those debts from the assets that he has. That is when a person is declared as an insolvent. Right? Once you have been declared or adjudged to be an insolvent, friends, you lose capacity to contract. Right? So we have today insolvency and bankruptcy even of companies. This is called the Insolvency and Bankruptcy Code of 2016. It's a new code that actually defines corporate insolvency and bankruptcy as well. So which means companies no longer have that kind of a position. But nevertheless, please note, there is no absolute bar in contracts for an insolvent and a bankrupt company, because finally you still have to dispose the remaining assets and try to discharge however much ever debt you have. But the complete capacity at being insolvent is actually not there, right? So that is when insolvency comes in and it drives away the capacity, it shrinks the capacity. And interestingly, most of what an insolvent or a bankrupt person, both legal or natural, I think it is now left to, say, an official liquidator, or it is left to, say, an NCLT, to actually see what kind of contracts are permitted and who will actually buy the assets of an insolvent person or an insolvent company. Right? So that is the process in which insolvency steps in. So insolvency and bankruptcy very clearly is a disqualification to contract, and hence unless there is intervention of law, protection of law, the assets of the insolvent cannot be dealt, and the capacity to contract is definitely taken off. Finally, friends, there is a kind of a traditional concept of an alien enemy that generally which meant that you should not contract with an enemy state, right? Once a country has been declared as an enemy state, any individual of that state is considered as an enemy, and your contract with those is not something that governs the capacity in contract law. So that's an exclusion is there, right? Enemy states are not to be encouraged, enemy citizens are not to be encouraged, and there is a deemed presumed incapacity for the parties from an enemy state to contract with a citizen of India. That's how incapacity comes in. Now, this is basically protecting national interests, why this kind of incapacity comes into place. And you will notice that there are today sanctions that are developed in international law, and any contracts based in violation of the sanction is not going to be valid. Right? So sanctions very clearly prohibit contractual relationship. They affect contractual relationship internationally. Right? Say today there is a crisis in Ukraine, and a lot of countries have imposed sanction on Russia. So contracts with Russia, Russian citizens, Russian companies are now going to be affected. Right? So you can't make a contract or form a contract after the sanctions come into place. It's not necessarily in terms of enemy state, but that's how international law deals with. So the capacity to contract then gets also affected in those circumstances as well. Fine, friends, I think this should be a good discussion on who has capacity to contract. We have kind of made an elaborate discussion on minors, unsound persons, and persons in a legal capacity, juristic persons as well. So we should complete our discussion here based on the capacity of parties. We should now move further to the chapter of consideration, which I think is also an essential test in contract, and that we should do immediately after we close the discussion. Now, moving forward, friends, another essential part of a contract enforcement test is the test of consideration. Interestingly, Section 25 of the Indian Contract Act says that if there is no consideration, there cannot be a contract. So consideration is so vital to actually hold an agreement as a contract. So without consideration, there cannot exist a contract. That's the statement that is there in Section 25. So what happens if an agreement has no consideration? Please note, the agreement is considered void, right? So which means it's not going to be enforceable at law at all. So what do we understand by consideration? So what consideration actually means? Of course, when there is an offer and an acceptance, and you expect parties to be in a commercial relationship or commercial transaction, consideration supports the contract, right? So the normal understanding of the word consideration means that there is a price between the seller and the buyer, right? So the seller will sell you at some price, which the buyer has to pay to actually procure the goods. So in that sense, consideration is the price to the promise or price in the contract. Very often, not many of us also understand consideration as being money that is exchanged in the commercial transaction. You have to pay to buy, you have to pay to get services. And that's consideration to that extent, which means anything that is done out of charity may not be consideration, is what we generally understand. But however, you will notice that consideration has a wider definition or a wider understanding, and consideration could actually mean some interest or some right that has been foregone in the contract. That's also sufficient, right? It could be some kind of a detriment or a loss that one occurs in that contract. That can also be consideration. So consideration is not necessarily something that is equated by money or economic value. It can also be equated through some right, interest, benefit, or please note any detriment, loss that a party may suffer in that contract as well. That could also be consideration, right? My efforts can be consideration. My intention to give charity can also amount to consideration, because I may get some greater satisfaction in doing charity or making a gift to someone. So it has a broader context, and please note, if you look at the definition of consideration under the Indian Contract Act, which is provided in section 2D, it can be an act itself. An act that is done is also consideration, right? So in furtherance of a promise, if I act for that promise, that is consideration, right? Let's assume that you make an offer. You say, can you run 10 kilometers within 30 minutes? And if I run, right, it's not necessary. Look, my action of running is a consideration and also an acceptance of the contract, right? So if I complete the running of 10 kilometers within 30 minutes, friends, I have supported the contract by consideration, and I will be entitled to the contents of the offer that you have made. That's how consideration is taken due note of. Also, friends, why is the law on consideration so very essential? Because when you understand consideration, friends, you understand the justification for enforcement of the promise. When consideration evolved in common law, the evolution was that judges required some justification to enforce the contract. They needed some reason to enforce the contract. Right? What is the causation for this promise to be enforceable? So if the other party has contributed to that causation, or causa as it is called in Roman law, or if the other party has actually justified the quote, look, from my talk, actions and deeds, this promise is enforceable by law. Whatever that other party has done would be considered as consideration. So to a larger extent, friends, in common law, the idea of consideration was the idea of justification for the enforcement of the promise. Right? And obviously, we say consideration should be something commercial, it should be something that is viable in a society, and that could be of some value that the courts and the judges feel that this is a valuable consideration for which the other person's promise must be enforceable at law. Also, it's like, consideration is something for something. It's like quid pro quo, right? If, you want me to fulfill my promise, let us see what you have done in exchange for the fulfillment of the promise, right? So if you have done something in exchange of the fulfillment of the promise, then I think you have given consideration, and hence you can enforce my promise. So this is how the whole idea of consideration got developed from time to time. Obviously, you need consideration to be legal. You don't want illegal considerations. So you will notice that even this aspect of quid pro quo is kind of defined in corruption cases. But here the quid pro quo is in terms of something for something that justifies a contractual enforcement, right? So it's not quid pro quo in the sense of understanding what happens in corruption allegations. So in the context of contract law, if consideration is something, what would it be? Say 1. Do you think it's the monetary value of the contract? 2. Is it a sum paid by one party to another party's offer? Is it the sum that is paid? The act of considering the terms of contract before agreeing to them. Or would it mean the price paid by each party for the other party's promise or performance? What could consideration be? Right? I think to a larger extent, friends, consideration can be all of these. That's a possibility. Right? So it is quite wide in that context. Now, to understand consideration, friends, we have to understand it from the fact that, look, the law make a prescription. It says consideration is essential. If not, there is no contract. So it makes a strict rule. However, if you look at section 25 itself, it crafts certain exceptions. It immediately says there are exceptions. The exception is, look, consideration is not required in a relationship that is of love and affection. Like the Balfour versus Balfour case that we discussed earlier. It's not required. If the same had been put in writing and if it's registered, right? Any kind of registered document for friends would not require consideration because the parties have understood that this is commercial and that's why they're going for registration. So there are exceptions in the law for the strict rule of requirement of consideration, and now we say, look, in certain cases consideration is not required. We can go over with consideration in certain cases. For example, gift. Now, when a donor gives something to a donor, the donor is simply accepting. What is the consideration that the donor has given or the one who is accepting the gift has given in the contract? Maybe nothing. And hence, gift is an exception to consideration. Right? Certain domestic relationships, out of love and affections, if you make a promise, if you then put it in writing and get it registered, again, no consideration is required. So the wife need not give consideration to seek maintenance from the husband, provided the same is in writing. So that's how probably consideration has evolved through the exceptions. And interestingly, to point this out, today the exceptions have literally outgrown the rule itself. Right? And that's why we say, in many cases, in modern form of contract, the test of consideration is dispensed of. The judges are not really worried unless it is challenged, because in modern commercial contracts, most of them are written, and the registration law seeks registration as well. In those cases, consideration is never argued, tested. But yes, when was consideration essential? Friends, in most cases where oral contracts have been made, consideration is very essential, and that's how this importance of consideration grew over a period of time. Now let's take a case. It's a very interesting one in trying to understand where is the test of consideration, or how is necessary the test of consideration. Friends, let's imagine that a company that is selling chocolates comes up with a promotional scheme. Right? They come up with a promotional scheme wherein they said, look, you buy our chocolates, right? You consume it. Now the wrapper and the chocolate, right? They're usually of no value. What we do with the wrapper is we throw it to the dustbin. But if this wrapper now is sent back to us, the company says, let's say you send 100 wrappers back to us, then you'll be entitled to an additional price. Right? So this was a scheme that Nestle company probably came up with. Right? So friends, continuing with understanding consideration as an essential element to fulfill the validity of a contract, one will also come across two very interesting principles and doctrines that have emerged from this concept of consideration. First is the privity of contract, and second is the doctrine of promissory estopping. Now, if you look at privity of contract, friends, the term privity means that who should be able to get rights under a contract. Now, this concept, though, has very traditional connotations and has a very conservative approach in one sense, has a lot of implication to modern day contracts. So, privity of contract, generally, if you go by the strict rule of it, says that, look, only parties to the contract should have rights to sue each other in the contract. Of course, so if I and you are making a contract, only both of us should have rights against each other, right? So you can sue me, I can sue you. That's it, right? However, the question has always emerged as whether third parties can get rights in the contract. So just to give you a modern example, say I and you make a contract and you employ a subcontractor. Now please note, I and you can sue each other for this contract, but your subcontractor, if suppose he does not get paid or he has certain issues and challenges, can he sue either me or you? Because please note, his work is arising from our contract. So can he get the right to sue? Right? Now this could extend to even the right to invoke arbitration as well, because in modern forms of contract, we have arbitration clauses as well. So the strict rule on privity, please note, did not allow third parties any rights. They said, look, he's not signed the contract, he's not a party to the contract. If he's not signed or he's not a party to the contract, he does not get rights to sue in the contract. It's as simple as that. Right? However, please note, the common law came up with this very strict rule of privity, and once it came up, it started creating some kind of an exception. Because please note, there are circumstances in which third parties ought to or will have to get rights in a contract. Let me give you a very simplistic example of the same. Now let's assume that you are the bank and I have taken a loan and we have a contract of this loan. Now the tenure of the loan is 3 years and I have taken the principal amount, I have to return it back with interest, and this is the contract between me and you. Tomorrow, imagine friends, unfortunately, I die, right? Now, will my son or daughter have rights on this loan agreements? Because, of course, there is going to be inheritance, there is going to be succession to property. So, contract that is made by a deceased person, interestingly, will have to create rights in the successors, right? So, though they are not a party to the contract, they must get certain rights in the contract. Probably, please note, when we talk about rights, we also talk about liabilities in that sense. So, the concept of this third-party rights is quite interesting because, under consideration, we say that only the parties to the contract have given consideration to each other. Hence, if you are given consideration, you get the right to sue. Interestingly, third parties have not given any consideration. So, why should they get the right to sue? That's the logic behind the whole concept of the privity doctrine. Now, please note, if the third party can come to the court and claim that, look, though they are parties, I have given consideration. Now, what is the consideration of a subcontractor? I have supported this contract. Without me, this contract would not have been completed. Who are these subcontractors? They could be the plumbers, the electricians, the masons, the carpenters who are actually constructing a house. So, I have worked over that. I have done an act already. Now, whether I am party to the contract or not, that doesn't matter. I have worked. My labor and skill has already been contributed. I have rights. I have duties here. So, I should get the right to sue. So, that way, I think third parties can generate rights, right? So, if you go by cases of this Dunlop Tire versus Selfridge, this is a very classic case of a tire company, having a contract with a wholesaler, right? And then the wholesaler having a contract with the retailer. Now, the question was whether the tire company can sue the retailer, or even otherwise, let us assume, can the retailer sue the tire company without suing the wholesaler, who is the intermediate party, right? So, we say generally, friends, if the chain of the contract exists, say between A to B and then B to C, and if this chain of this contract is not broken, then A should get the right to sue C, or C should get the right to sue A. That's ideally the situation how privity is diluted to give rights to third parties, right? So the privity of contract does not allow, but exceptionally certain parties who are third parties do get the right to sue under this contract. Now you have to also note that under the Specific Relief Act of 1963, third parties can also bring certain claims in a contract. Yes, right? So if my son has to recover the loan to the borrowers, he should also be given the right, isn't it? So third parties do get right to file claims and suits and on contracts as exceptions to the doctrine of privity. Common law was obsessed with the doctrine of privity, excluding third parties the right. Later on, they started understanding the difficulties and the realities of the situation and said, look, certain kinds of third parties who probably are one in the chain of the contract and the chain has not been broken and hence they have obligations. Because remember, the retailer is still handling Dunlop tires. The brand of Dunlop tires is what he is finally selling. Right? Dunlop may not have a direct contract with him, but finally Dunlop knows that this retailer is going to sell his goods, and the retailer must also know that they are not only acting for the wholesaler, they are acting for the tire manufacturer as well, right? In that sense, I think the role of third parties is very clearly something that the doctrine of consideration in Indian law clearly establishes, and to that extent, you notice that in India, the privity doctrine is a diluted doctrine. There are exceptions to this doctrine, and a lot of these third parties do get the right to sue. Let me give you another instance or an example. Generally, where do you see these third parties? Let's assume that you want your house to be painted. Okay, and I am the painter. You give me the contract to paint your house. Now, I am supposed to go and buy paints, right? So I go to the shop, I buy paints. The contract is between me and the shop. But finally, whom am I buying the paints for? I'm buying for you. Okay? So you, me, and the paint shop. Right? We three have a chain. You give me the money, only then I could buy the paint. But the contract is between me and the paint shop. Tomorrow, if the paint is defective, as the owner of the house, can you sue the paint shop for defect in the product? The answer is yes, you can. Right? Though you're not a party, finally, because the contract between the painter and the paint shop was made for the benefit of you. You are the final consumer, the user, you funded it, it was your house that was to be painted. You get every right to sue the paint shop for any defect in the quality of the goods. That is the process in which the privity doctrine becomes a very important doctrine to understand who gets the right to sue in a contract and who does not get the right to sue in a contract. Okay? Now, friends, the understanding was very clear that if you do not support the contract with consideration, you should not get the right to sue. But then please note, there are circumstances in which you may not support the contract by consideration, but still you should get the right to sue. For example, suppose I and you make a contract for, say, a minor. Right? You and I both say, let's assume that we are two parents, and we say, look, there is a minor son to whom we should give maintenance every month. Right? Now the minor, because he is named in the contract and he is the beneficiary of the contract, please note, any person who is named in the contract and who is a beneficiary of a contract gets the right to sue, though they are not parties to the contract. That's how the exception has been crafted out to the privity principle. So there are many such exceptions in which parties do get the right, and I think that is where third party rights in contract becomes a very important discussion. It is actually an important principle. And sometimes, please note, it is used as a defense to exclude parties' claims and suits and rights. But at times, you will notice that if someone who wishes to sue, someone who wishes to exercise rights, if he can prove consideration, if he can prove the beneficial interest from that contract, then the courts usually would decide the beneficial interest and award contractual remedies to such parties as well. So that's a very interesting way of looking at the doctrine of consideration and the privity principle. And in India, it was very clear from the definition of consideration that third parties usually can get this right to sue, provided they are able to support the contract in one way or the other. Now, we know insurance contract. This is very interesting because please note, in insurance contract, we say third party insurance. Right? So you take an insurance for your car, you pay the premium, the contract is between you and the insurance company. That's the contract. But who is the beneficiary of this third party insurance? Please note, anyone who actually meets with an accident from your motor vehicle. He is not known. It may happen, it may not happen, but the insurance is for that third party. And the third party can actually claim or sue on that insurance as well. So there are many such instances where third parties have been provided either rights through a separate statute. Say the Negotiable Instrument Act could be one such exception, because see, I have an account at the bank, correct? It is the contract between me and the bank. But can I issue a check to a third party, and can that third party sue the bank if the check is not realized? Correct? So under Negotiable Instrument Act, we have created the right of third parties. Under trust law, we have created the right of third parties, because in trust, please note, the trustee is managing for the beneficiary. The beneficiary is not part of the whole transaction or the whole authority that is being granted to a trustee, but the trustee's role is only for the beneficiary, the third party. So that way, I think if you look at even our personal law where partitions were allowed, where two brothers had to provide for the marriage expenses of their sister whenever the property, ancestral property, was to be divided, the sister could sue under that family partition deed because she was named in the partition deed. So this were all rights granted through statutes, through customs, and then we are talking of contracts, right? And that's how the third party issue gets finally brought into some kind of legal system. And I think the legal system does entertain third party rights, provided third parties are able to prove that they have beneficial claim or interest, or there is an adverse impact on their rights in the contract for which the courts must entertain their claims. Right? That's how we talk about it. However, the privity principle is also very important because at times it can be a great defense against the rights of third parties. Now, coming to the final aspect on the aspect of consideration, we have to discuss the doctrine of promissory estopping. Friends, this doctrine is very relevant and important for government contracts, tendering and public procurement, because this doctrine primarily has been used in cases where government has entered into contract, and this rule has been applied against the government so that the government actually goes and completes its promise. So this doctrine is important in that context, and I think the case that one should read is this Motilal Padampat, Sugar Mills versus the State of UP. It's a 1979 judgment of the Supreme Court, which was delivered by former Chief Justice of India, late Sri Bhagwati, P.N. Bhagwati. Now, you will notice that in the MP Sugar Mills case, the facts of the case go something like this, that the government had actually come up with a promise saying that in case you come and establish an industry in Uttar Pradesh, any new industry, that industry will be given a tax holiday. So not taxable for 3 years if you establish a new industry in Uttar Pradesh. This was the promise that was given by the state of Uttar Pradesh. Now, Motilal Padampat Sugar Mill, they were keen to establish a plant in Uttar Pradesh. They were not sure whether this general direction of the government giving a 3-year tax holiday applies to them in specifically because they are a sugar mill. See, they wrote to the Secretary of the Industry in Uttar Pradesh and they said whether this order will apply to us as well. And the Secretary replies, he says, yes, it will apply to you and you are going to get a 3-year tax holiday. Now, after this promise was made by the Uttar Pradesh government, Motilal Padampat Sugar Mills went and bought a piece of land and they were about to start their factory. Unfortunately, the political situation in Uttar Pradesh changed and the government changed. And the new government that came in, they said, no, we will not adhere to this 3-year tax holiday. That is creating a loss to the exchequer. So we are reversing the same. Aggrieved by the reversal of the new government, MP Sugar Mills goes to the court and they say, look, it can be reversed, but for prospectively. Right? But we have already acted on this promise, and hence the promise is binding. So the Supreme Court here, it was a situation at the time when the judiciary of this country was asserting itself as against the executive actions of, say, post-emergency and so on and so forth. And the judiciary was trying to claim its independentness and autonomy. So these were changing times, and the Supreme Court was actually headed by some very brilliant judges who were changing the legal landscape in this country. And Justice P.N. Bhagwati in this case clearly says that look, once the government has made a promise, it should be stopped from changing the promise. Right? So promises are binding. And if promises have to be changed for the government, they should act prospectively and not retrospectively so as to adversely affect the interest of either individual citizens or corporate citizens, as in this case, the MP Sugar Mills. Look, there was a promise made by the government, 3 years tax holiday. That promise was acted upon by MP Sugar Mills. They have already bought a piece of land. For them, this promise is binding. That's how promissory estoppel. Now, estoppel means, friends, it is like saying you are stopped from, doing something. There is a prohibition, right? Estoppel, to stop you from denying what you have said in the past. The rule of estoppel, friends, is found in section 115 of the Indian Evidence Act. And it's just the plain rule of estoppel. And it can be used as evidence to stop someone from denying a statement or a claim or a promise that they made in the past. And promissory estoppel is an extension of the same in common law. Lord Denning used this in common law in the UK. And he said, look, estoppel as a rule of any statement or a promise even applies to contractual promise. So once a contractual promise has been made and it has been acted upon, you will be stopped from changing that promise so as to adversely impact the other parties. That's how the doctrine of promissory estoppel evolved. Now, applying this to government was a natural thing because government also makes promises, government also makes contractual arrangements, and hence, once the government has said, look, you are going to be the contractor for the 5 years, the government from the stopped from changing the contract or changing the promise in the contract. That's how promissory estoppel started applying in government contracts, mostly invoked in government contracts, so as to stop the government from changing its claim and promises and statements. And contractual certainty and consistency can move from one government to another, in a sense, because remember, governments remain the same. It's only the political parties in the government who change. And hence, to bring that political certainty, I think the promissory estoppel was applied in this particular case. But remember, it's not an absolute rule. We have to understand this. And the courts, over a period of time, very clearly has said, look, legislative change can bring a change in contract. There you cannot bring about a rule of promissory estoppel. Promissory estoppel applies for executive action in the government. But if the parliament thinks that a contract is against public policy and they want to reverse it, like probably it happened in the case of West Bengal, Nandigram, and so on and so forth, that legislative change is which the legislature can definitely bring about. If they think that a contract is not in public interest, is against national security, the legislative change can definitely happen. Legislations don't have estoppel. Only executive actions, which are basically the actions for contract, have the rule of promissory estoppel. So it was a great doctrine, it was a great principle, something that was derived from the chapter of consideration, from the concepts of consideration, and then applied to modern day kind of government contracts. There are many cases on government contracts that are used in this case. So with this, friends, I think we should close the discussion on consideration. You will notice that we have said consideration is very, very critical. Without consideration, there is no contract. We have said that there are 3 types of consideration: past, present, and future. We have also said advocacy of consideration is important, but not something that you can not be done away with. We have looked at privity. We have looked at promissory estoppel. So this has been quite a good discussion on the most essential aspect of contract that is on the chapter of consideration. Friends, with this, I think we should move on and move on to another very important and critical aspect, which clearly brings about. This is the 108th Law Commission report, which discusses promissory estoppel. But we should move to the next chapter, and the next chapter of understanding is on consent. Friends, you will notice that parties in a contract are in a private relationship. They are not in a public discourse. They are not a part of being a citizen as against the state. It's not constitutional or administrative law. It's not public law. It's private law. Contract is a private law. So you can enter into a contract only if you wish to enter into one. No one can force you to enter doing the same. So free consent is one of the essential tests of a contract. Have you agreed to the contract out of your free will and choice? This has to be tested. If it is not, if one of the parties goes to the court and says, sir, look, I have been forced into the contract, then the courts will be compelled to hold the contract as not being enforceable. Rather, we say it is voidable. Right? So the parties whose consent has been vitiated by any of these actions, it can be coercion, right, undue influence, fraud, misrepresentation, or a mistake, they have the ability to go to the court and seek refuge and say, sir, the contract should not be held enforceable against any of us because we did not agree to the contract out of our free will and choice. So consent is a very, very essential test to contracts, right? So that's what we must understand.